solemnly swear or affirm the testimony you're about to give before the court is the whole complete truth, self you got it?
I do.
I need to ask you to speak loudly and clearly, so you've got to take down everything you say in the record, so you got to get it.
Yes, sir. Yes, sir.
All right, sir. I have been provided with petition to enter a plea of guilty in your case. I need to ask you several questions to make sure you understand the contents of this plea petition, to make sure that you're competent to enter the plea, and make sure you understand the rights you have as a criminal defendant. While we go through these proceedings, you've already been instructed to answer my questions verbally so the court reporter can take down your response. I also want to instruct you that if I ask a question you don't understand or say something you don't understand, please stop me. These are very serious proceedings. I want to make sure that you and I are on the same page. And secondly, if at any time you need to consult with your attorney, just let me know and you'll be able to consult with him privately before we go any further. Have you understood my instructions?
Yes, ma'am.
All right. How far did you go in school, sir?
I graduated high school.
So you are able to read and write?
Yes, ma'am.
Are you taking any medication, prescription over the counter, or otherwise?
No, ma'am.
Have you consumed any alcoholic beverage or other intoxicant in the last 24 hours?
No, ma'am.
Have you been diagnosed with or are you suffering from any mental illness or mental disorder?
No, ma'am.
Is there any reason you can think of that would affect your ability to understand what you're doing here today?
No, ma'am.
You are under oath, and that means you've sworn to tell the truth. Do you understand that?
Yes, ma'am.
You have provided the court with a plea petition that has a signature. Did you sign this petition?
Yes, ma'am.
And before you signed it, did you have an opportunity to read it in its entirety to yourself or to have it read to you by your attorney or some combination of those things?
Yes, ma'am.
And during the time that you were reading the petition or it was being read to you, if you had any questions, were they answered to your satisfaction?
Yes, ma'am.
Do you believe you fully and completely understand the contents of this plea petition as you stand here today?
Yes, ma'am.
Sir, you are charged by way of what's called a criminal information. I need to talk to you about that just a little bit. Anytime you're charged with a crime, you have a right to have the Davidson County grand jury hear your case. The grand jury is a body that investigates whether a crime has occurred, what level of crime, and whether or not you had any involvement in the crime. By signing a criminal information, you are waiving your right to have your case presented to the Davidson County grand jury. Is that right?
Yes, ma'am.
All right. You are charged in case 2024 I-687 with 2 counts of misdemeanor reckless endangerment. Those each carry a maximum punishment of 11 months and 29 days in jail and a fine of up to $2,500 on each count. Is that your understanding of what you're charged with and the punishment you could receive?
Yes, ma'am.
You understand you're charged with more than 1 count, and I want to make sure you understand if you were convicted of 2 counts, you would receive a separate sentence for each of those counts. Do you understand that?
Yes, ma'am.
I understand. Do you understand what it takes under the law to be found guilty of what you're charged with, sir?
Yes, ma'am.
I understand that you are entering a plea of guilty to 2 counts of reckless endangerment. You will receive a sentence of 11 months and 29 days, all suspended except 7 days incarceration, which will be served in a DUI education center. The remainder of that sentence will be served on supervised probation. These counts run consecutive to each other, that is, one after the other, for an effective sentence of 2 years. And the sentence is pursuant to judicial diversion, which we will talk about a little bit later. Is this your understanding, sir, of what you're pleading guilty to and the punishment being imposed?
Yes, Your Honor. We talked about the formal conditional guilty plea, but yes, he understands that.
All right, but those are the offenses that he understands he's pleading guilty to and the sentence, which is a 2-year sentence.
Yes, ma'am.
All right. Do you have any questions at all about what you're charged with and the punishment you could receive, that is the maximum punishment, and what you're pleading guilty to and the punishment that is being imposed?
No, ma'am.
Before you decided to enter this plea, did you have enough opportunity to speak with your lawyer about the facts and circumstances that led to this arrest?
Yes, ma'am.
And during those discussions, did he talk to you about the law that applies to your case as well as the evidence the state says it has against you?
Yes, ma'am.
And during those discussions, did he explain the defenses you might have to these charges, that is, the evidence you would use to overcome or negate the evidence the state says it has against you?
Yes, ma'am.
And during those discussions, if you had any questions, were they answered to your satisfaction?
Yes, ma'am.
Do you have any complaints at all about the representation your lawyer has provided?
No, ma'am.
All right, sir. The following questions address the rights you have as a criminal defendant, because when you enter these pleas of guilty, you are waiving or giving up those rights. So please listen carefully so I can make sure you are knowingly giving up your rights. First of all, do you understand you have the right to continue to plead not guilty, demand a trial by jury, and require the state to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And do you understand if you did demand a trial by jury, you are entitled to a public and speedy trial by jury?
Yes, ma'am.
Do you understand if you were to demand a trial by jury, it would be the state's responsibility to prove your guilt beyond a reasonable doubt, but you have no obligation to prove that you're innocent because under the law you are presumed to be innocent?
Yes, ma'am.
Do you
Morgan
understand?
Wallen entering a plea there. We do have to hit our break. We're at the top of the hour. Our thanks to Tamika Rabowski for her analysis this hour. More of the Morgan Wallen plea hearing after this. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this afternoon. We are paying attention to several major trials happening here on Court TV. Here's a look at what we're tracking this hour. In Vermont, closing arguments are underway in the Van life and death murder trial for defendant Joseph Ferlazzo. He took the stand yesterday to tell the jury he shot his wife in self-defense in their van after a fight broke out during a vacation celebrating their first anniversary. We're also looking at the courtroom in North Carolina. It's day 2 of testimony in the convenience store owner case accused of killing a customer. It's Taz Zarka, who's accused of stabbing Mark Garrity after Zarka allegedly witnessed Garrity stealing a Gatorade. And in Tennessee, country music star Morgan Wallen back in court today for a plea hearing, and that's what we're going into now, picking up right where we left off.
Jury, you are entitled to a impartial trial by a jury of your peers made up of citizens of Davidson County.
Yes, ma'am.
Do you understand, had this case gone to trial, you would have the right through your attorney to cross-examine any witness the state called to testify against you? He could question their memory, their truthfulness, and bring forward any pertinent facts about your side of the case.
Yes, ma'am.
And do you understand you have the right to use the subpoena power of the court to require the attendance of any witness that could testify for you if there were such witnesses?
Yes, ma'am.
Do you understand, had your case gone to trial, you could testify on your own behalf, but only if you chose to do so, because you cannot be made to testify and give evidence against yourself. And if you decided not to testify, the jury would be instructed that it could not consider your decision not to testify as evidence of your guilt or for any other purpose.
Yes, ma'am.
Do you understand, had you been found guilty at trial, you would have the right to have a jury set any fine greater than $50, and the court would set your punishment at a separate sentencing hearing?
Yes, ma'am.
And furthermore, if you were convicted, you could appeal your conviction as well as any punishment imposed to a higher court. And if that higher court found you did not receive a fair trial or a fair and proper sentencing hearing, that court could grant relief, including the possibility of a new trial.
Yes, ma'am.
And do you understand, sir, that through all of the proceedings I've just gone over, you have the right to an attorney? And if you could not afford an attorney, I would appoint one for you, and that includes if you went to trial, were convicted, and wanted to appeal that conviction.
Yes, ma'am.
Do you have any questions at all about the rights you have as a criminal defendant?
No, ma'am.
Do you understand if I accept this plea of guilty here today, that ends your case in this court once and for all? There is no further discussion, there is no jury trial, no sentencing hearing, and no appeal.
Yes, ma'am.
Sir, you are pleading guilty pursuant to what we call judicial diversion. That is a particular statute for first offenders that allows you, if you successfully complete all of the terms of your probation and have no other arrest or problems with the law, you may then petition the court to expunge all public record of these offenses. On the other hand, if you do not successfully complete your probation or you have other arrest or trouble with the law, you run the risk of losing your judicial diversion status. And if that happened, these offenses convert to convictions on your record. Do
Yes.
you understand that, sir?
I understand.
Has anyone threatened you with anything or promised you anything in order to get you to enter this plea?
No, ma'am.
Are you entering this plea of guilty because you are guilty, sir?
Yes, ma'am.
All right, for counsel, Mr. Robinson, do you believe that your client understands the nature of the charge against him, the law that applies to the charges, the pros and cons of entering the plea versus going to trial, and that he is entering the plea freely, knowingly, and voluntarily?
Yes, Your Honor.
All right, thank you. Let's do the facts, please.
Your Honor, if this matter proceeded to trial, the proof would be that on April the 7th of 2024, the defendant was at Chief's Bar and Restaurant located at 200 Broadway Avenue. The defendant was on the 6th floor of the rooftop bar. The defendant picked up a chair, threw it off the 6th floor. The chair landed on Broadway, approximately 3 feet from where Officers Gavin Treese and Officer Yaroslav Holokov were standing, placing them in imminent danger of death or serious bodily injury. All these events happened in Nashville-Davidson County, and based on those facts, the state would recommend the previously announced agreement. And Your Honor, I'd like to say that Officers Gavin Treese and Officer Holokov were both consulted about this plea and both approved it.
All right. Thank you. Mr. Wallen, did you hear the facts as read by the Assistant District Attorney?
I did hear
Are
that.
those facts true and correct?
Substantially, yes.
Substantially, yes.
Are you waiving your right here today and entering a plea of guilty in your pending case?
Conditionally guilty, yes.
Conditionally guilty, yes, ma'am.
In case number 2024-I-687, where you were charged with 2 counts of reckless endangerment, how do you plead, sir?
Conditionally.
Conditionally guilty.
All right, Mr. Robinson, anything further before I accept the plea?
No, Your Honor.
All right. Mr. Wallen, based upon your plea of guilty, I do find you guilty. I find there is a factual basis for the plea, that you are competent to enter the plea, and that you're doing so freely, knowingly, and voluntarily. So I will place into effect the previously announced plea agreement. That
Okay.
concludes this proceeding.
Thank you.
Thank you, Your Honor.
There you have it, the country music star walking out of the courtroom after agreeing to plead guilty to the reckless endangerment charge against him for throwing that chair off of that 6th-floor rooftop bar. Let's bring in our guest who's here in studio, criminal defense and civil attorney Jesse Law is with us. So good to have you in studio.
Thank
I
you.
got to ask you this just first off. When he's saying conditionally guilty and substantially when he's saying that he agrees to it, what does that signal to you?
I really don't want to plead guilty. I really am not guilty, but it's based on the best advice I've got from my lawyer. This is the best route to go right now. Resolve the matter, put it behind me. I don't get jail time. I get to be on probation, or you know, I do community service or something. But I just do take the easy path to resolve a criminal matter against me. And possibly, I'm not that familiar with conditionally guilty, but I think it may not have permanent ramifications on his record. But y'all can check into that, because
It's almost like a no-low.
it's like a
type
no
of
low contendere, no contest. If you are qualified for such a plea, you can put that in, and it won't go on your permanent record, and one can't use that against you if you are ever arrested again in the future. So it's a cop-out.
Could be.
Yeah.
You know, so he faced 3 Class A misdemeanors there in Tennessee. 129 days, what the judge made sure he understood he could have faced if he had gone to trial on this. We're understanding 2 years probation and perhaps 7 days in jail behind bars. You surprised that if there is the 7 days, that there is any jail time for someone who is as high profile as Morgan Wallen?
Well, I think it might be 7 days in jail if the judge wants to impose him, but she could also give him credit for the time he's already served. So he may be in jail for a minimal amount of time, not necessarily all 7 days. And 2 years probation, she probably tacked it on a consecutive for each count. And that's not unusual. And the good thing about probation also is if you complete all your conditions, he can petition the court and more likely than not be granted a non-reporting probation, or probation could terminate if he's been a good boy, finishing all his conditions with no complaints.
How much do you think it exacerbates things that there were police officers nearby? Whether or not he knew that throwing that chair over the rooftop was going to land 3 feet away from officers, but when you're talking about prosecuting a case like this that is so public because of his fame, how does that play into it?
I think the seriousness totally undercuts his ability to put out a strong defense in this case. Because the officers were nearby, it could have been a more egregious situation if someone was actually struck. And then you have officers, you know, who doesn't believe officers, right? And especially in a trial. So when you have this kind of situation and you are potentially could have harmed someone in a uniform, you know, it totally undercuts his ability to put up a solid defense.